Hi, I'm Emily and I am here with Maya Murphy's attorney, Lauren MacDonald. Attorney MacDonald practices at Maya Murphy's Westport, Connecticut office and is admitted to practice law in both Connecticut and New York. My question today for Attorney MacDonald is, what is a due process hearing?
A due process hearing is a legal proceeding that ensures fairness in the decision-making process regarding your child. As a parent, if you disagree with a proposed or refused action pertaining to your child's education, you or the school district may initiate a due process hearing to resolve the disagreement. In Connecticut and New York, you may file a due process complaint within 2 years of the time the school district proposes or refuses to: 1, consider or find that your child is disabled; 2, evaluate your child; 3, place your child in a school program that meets his or her unique individual needs; or 4, provide your child with a free, appropriate public education, otherwise known as FAPE, that meets your child's needs. If your school district has not provided you with a copy of your rights to bring a complaint, then according to the Connecticut State Department of Education, the 2-year limit shall not begin until you receive a copy. Whether you live in Connecticut or New York, you must forward a copy of your due process complaint to the appropriate state educational agency, which in Connecticut is the due process unit of the Bureau of Special Education, and in New York, it's the New York State Education Department. The due process complaint must include the name of your child, the address of the residence of your child, the name of the school your child is attending, a description of the nature of the problem, including any related facts which you're aware, and a proposed resolution to the problem. The party receiving the request for a hearing has 15 days from the date of receiving the due process complaint to notify the hearing officer and the other party if they believe the request for the hearing does not include the required information. The hearing officer has 5 days to make a determination as to the adequacy of the hearing request and whether it meets the necessary requirements. If the hearing officer finds the complaint to be inadequate, you will have to file a new complaint. If the complaint is found to be adequate, your child's school district must, within 10 days, send to you an explanation of why the school proposed or refused to take the action raised in your complaint, a description of other options that the PPT or IEP team considered and the reasons why those options were rejected, a description of each evaluation procedure, assessment, record, or report the school used as the basis for the proposed or refused action, and a description of any other relevant facts the school relied upon in its proposed or refused action. Within 15 days of the school district receiving notice of the due process complaint and prior to the initiation of a hearing, the local education agency must convene a meeting with you and other relevant members of the PPT or IEP team meeting who have specific knowledge of the facts identified in the complaint. The purpose of this meeting is for you as a parent to discuss the due process complaint so that the LEA has the opportunity to potentially resolve the dispute without having to begin a due process hearing. This meeting does not need to be held if both you and the school district agree in writing to waive the meeting. If the LEA has not resolved the issues expressed in your due process complaint to your satisfaction within 30 days following receipt of notice of the complaint, the due process hearing may begin. A final decision must be made by the hearing officer no later than 45 days after the expiration of the 30-day period, or adjusted time periods if you fail to participate in the resolution meeting in a timely manner. A hearing officer may grant specific extensions of time beyond the 45-day period for certain reasons at the request of either party. The hearing must be conducted at a time and place that is convenient for both you and your child. Both you and the school district have the right to be accompanied and advised by counsel at your own expense during the course of a due process hearing. Both parties may also be accompanied by individuals with special knowledge or training with respect to children with disabilities. Both parties may present evidence as well as confront, cross-examine, and compel the attendance of witnesses. However, parties are precluded from introducing evidence at the hearing that has not been disclosed to the other party at least 5 business days before the due process hearing. The hearing will be recorded, and upon your request, you also may be provided at no cost with a written or electronic copy of the hearing, as well as the hearing decision. If you receive an unfavorable decision after a due process hearing, there are two possible avenues of appeal. First, if the hearing was conducted by a public agency other than the state educational agency, you may appeal to the appropriate state agency. The state agency will then review the record, evidence, and other items relating to the initial hearing and make a final decision. Second, the state agency decision is final unless one of the parties opts for the second avenue, which is to bring a civil action in either Connecticut or New York state or federal court. The party who brings such an action must do so within 90 days from the date of the decision of the due process hearing officer or the state review official. If you have filed a due process complaint or have any questions about your rights to a due process hearing, please feel free to give me a call.